Yeah, and I have opened the recording, so you can just give your lecture.
Good, thank you. Hello, ladies and gentlemen. I'm happy to be with you, and perhaps it's still time to wish you a very good and happy new year. Today we will study the sphere of application of the Convention on International Sale, the Vienna Convention. We will study the first 6 articles. You have the text of the convention, isn't it? We study the first 6 articles today. Now, imagine that you are a judge, a Chinese judge. You are sitting in court in China, in Beijing or in Shanghai or in whatever, and you have to hear a case between a seller and a buyer, so a contract of sale, and they have a problem. There is a litigation. Uh, what are the obligations of the seller? What are the obligations of the buyer? You have a problem. You have to give a solution. You have to give a decision. What substantive law do you apply? That's my question. What law do you apply? Well, in fact, you have 3 choices. First, of course, if the parties are both Chinese parties, a Chinese seller, a Chinese buyer, you apply the domestic Chinese law. That's clear. That's no problem. But if there is a foreign element in the relationship, then you will have to apply, that's the second possibility, the Chinese private international law. That's now codified. It was codified in 2010, Chinese Code of International Private Law. And that code will point to a foreign domestic law, and the Chinese legislator orders you, Chinese judge, to apply that for foreign domestic law. Now, let me a bit first stay in this hypothesis. This private international law, you must realize that it's not international at all. Private international law, or conflicts of law, as they may call it in America, private international law is essentially national law. Each country has its own private international law. So it's not like the public international law, which governs the relations between the sovereign states and the international organizations. That law is unified. Well, there is only one international law, but that's not so for the private international law. Each country has its own private international law. That's national law. Now, in this course, I don't explain you what private international law is. You have another course for that. I think in the EU School of Law, it's my colleague Geert van Kalster, Professor Geert van Kalster, who is teaching that course. But of course, I have to, and we will see, we will very often have to refer to the private international law. And then I will say, well, the private international law, which is the private international law of the Forum Court, will indicate what domestic law applies. Now, this is not from the viewpoint of practitioners, from the viewpoint of international trade, this is not an ideal situation because it gives rise to uncertainty. It's not certain which law will be chosen by the forum court. So the practitioners, before that there is a litigation, they are not able to predict if we have a problem between us, which law will apply. It's not very certain. And for lawyers, as you know, this is something which they don't like. They don't like. Lawyers hate uncertainty. They want to be certain to give to their client a certain answer. If you have a problem, that's the law which will apply, and that will be the solution. That's what lawyers want to do. But up till now, you can do it. And therefore, there is a third choice which you, Chinese judge, have at your disposition, and that's, besides domestic law and private international law, pointing to a foreign domestic law. Third choice, uniform law. But that's only possible since 1980. Before that, it was a dream. International traders could only dream of this possibility. You know, this ideal possibility of just one uniform law valid for the whole world, which would be applied whatever the parties are, where they are situated, between a Japanese seller and an American buyer, between a Chinese seller and a French buyer, between a German seller and an Australian buyer. Everywhere, when you have a problem, the court, the forum court, so the court who has jurisdiction, will apply the same rules, a uniform law. But as I told you, that's only possible since 1980, since the Vienna Convention came into being, since the International Convention on the Sale of Goods, which we studied, came into being. And let me give you first some idea of the legislative history of this Vienna Convention. The institution who cared for it, who drafted the proposition after years and years of study, because of course that needed comparative law study to try to find solutions which would be acceptable by all the countries. That was an enormous work of comparative law. That happened in Unidroit. And Unidroit, that's an institution which was created by different states under the auspices of the League of Nations in 1926. 1926, that's already nearly a century ago. And in 1930, 4 years after the creation of Unidroit, which has its seat in Rome, a nice place. I visited it in Rome, and there was a working group who started to study the international sale, 1930. That's what they do since then. They care to find and to present uniform laws. For instance, to give you some recent examples, you have the convention. Well, that's what they proposed to the states to sign in a treaty. The convention on the hotel keeper's contract. What's the liability of an hotel keeper when tourists come in and they lose their luggage, or their luggage is stolen? Who is liable? Well, all those problems are, of course, to be solutioned by reference to the hotel keeper's contract, and there is a uniform law on that, which was proposed by Unidroit. Another very important example, and we will refer very often to that, it's the International Commercial Contracts Convention, a convention of 1994 on commercial contracts, international commercial contracts. You see, so the UNIDROIT is still working and doing very good work in the comparative law field in order to present laws to the. Of course, this law which they present is not binding. It's soft law. It's soft law. Now, the sales contract, on the sales contract, that will be different. That will be a binding law. Now, what happens to the sales contract? Well, I told you there was a working group in 1930 starting with that. And years later, only in 1964, this gave rise to a convention. The convention signed in Den Haag in Holland, in Den Haag in 1964. The first text existing in the world on international sales contracts. But unfortunately, that convention of Den Haag of 64 had not much success. Why not? Because, in fact, the Soviet Union was not implied in the negotiation, and neither did the developing, as they were called in those days, the developing nations. They were not implied. It was only negotiated between Western powers. And so there was no great success. But in 1964, the same date as when this, the Hague contract came into being, Hungary proposed in the United Nations to create a commission on the international trade. And that commission was indeed created 2 years later, in 1966. UNCITRAL was created, and this commission started to work. There was a working group, started to work on a convention on the international sale of goods. So it was the same subject as Den Haag, but they started the work anew with a new, fresh view on the problem. And indeed, it worked. It became a great success. In 1980, in Vienna, in Austria, 62 states signed the treaty, the Convention on the International Sale of Goods. This was the first international sales law who had success, who existed, and since then more than 80 states ratified that convention. So that means more than 3/4 of the world trade happens between countries which ratified the convention. So the convention is worldwide, is of worldwide application. I must perhaps add between brackets that in 80, not only the convention was applied, which you know, the Nations Convention on the International Sale of Goods, but there was also an amendment which was signed on the limitation period, an amendment to an earlier United Nations Convention on the limitation period. Limitation period is the prescription period. When is it too late to start a trial, to sue with success before a court? When is it the time prescribed? It's called in English a limitation period. Well, that's 4 years, but to make this earlier convention match with the new convention on the international sale of goods, there was an amendment needed, and that was also signed in Vienna in 1980. Now, what we saw up till now, let me resume just for a while. You see, we start by saying if you were a judge and you had a Chinese judge and you had to give a solution to a problem, which law would you apply? You have a choice at first sight between domestic law, Chinese domestic law, or Chinese private international law, but that leads to a foreign law system, or third possibility, uniform law, the Convention on the International Sale of Goods. Now, my problem, which I will come at now, is when will the judge, when will you have to apply the uniform law? Because you have some rules on the sphere of application. It means when are you obliged to apply uniform law and not your private international law leading to a foreign law system, so that you apply the foreign law system. When don't you do that? But instead you have to apply the uniform law. Well, that's the problem which Article 1 will give an answer to, and which we will look at now. So if you please want to do it, look at Article 1 of the Convention. My thing is always moving here. No, like that, it's fine, I think. Yeah. Now, if Article 1 says the Vienna Convention will apply when the two different parties, the seller and the buyer, when the two parties have their place of business in two different states. So the important word is here place of business, because you see, in earlier conventions, the Hague Convention, for instance, or earlier conventions, the term to link the application of uniform law was a different nationality. Here, as nationality has no role to play. If the seller or the buyer are of different nationalities, but they are in China, that's no problem. It's Chinese law which applies. Nationality is not the distinctive feature. You look at the place of business. And now you will say, but if there is no, if one of the parties has no place of business, no problem. The text says then it's the habitual residence, where that party resides habitually. The other possibility is also, well, they have more than one place of business. And then the text says that you have to apply the place which has the closest connection to the contract, the closest connection. Now, Article 1 says, that's a simple rule to start with. The most simple rule is you look at the place of business of the two parties, seller and buyer, if they have their place in different states, China and Germany, Japan and America, Italy and France, different countries, then the convention, the Vienna Convention, applies. That's Article 1(a). So that's a simple rule. But you must have, of course, the two parties residing upon or having their place of business in two different countries. If this is not the case, I mean, if one of the parties is not residing in a contracting state, yes, because of course Article 11A asks the two parties must reside in a different country, but that country must be a contracting state. Contracting state, remember that well, contracting state means a state which signed or which a state which ratified the Vienna Convention. That's a contracting state in our terminology here. Well, if the two parties have their place of business in different contracting states, then the Convention of Vienna applies. If this is not the case, so one of the parties is not residing in a contracting state, then Article 1(b) applies. I'll give you an example. England, for instance, England did not ratify the convention. That's typical for the English, you know. They have they sit on their island and they think that they are isolated, splendid isolation of England. Well, they didn't ratify it. Now, if you have a contract of sale between an English buyer and a Chinese seller, or between a Belgian seller and an English buyer, well, the two parties are residing in different states, yes, but one of the states is not a contracting state. And that's the hypothesis of Article 11(b). And then the court applies the private international law. It's private international law. So you see, this idea of private international law comes back here in Article 11(b). It's this hypothesis, not the only one, but this is important for the sphere of application of the convention. Now, the private international law doesn't give substantive solutions. It only points to the law, the foreign domestic law, or the foreign law which is applicable. And here in under Article 1(b), you have two possibilities. Either the private international law points to a contracting state, for instance, to the Chinese law, for instance, the place of business of the seller on the contracts is in China. Well, that's in international private law. That's often an indication to point at the competent to the competent law, to applicable law. It's not necessarily the place of business of the seller. For instance, in Argentinian law, the Argentinian private international law says in the case of a problem with the sale of goods, the applicable law is the law of the country where the goods are delivered. That's another place. So it depends. But anyhow, Article 11(b) says the private international law of the forum indicates either a contracting state, for instance, Chinese law, or a non-contracting state. For instance, we know the example of England. I can give you another example. India didn't ratify, up till now, didn't ratify the convention. So if the private international law points at the law of India, then that will be different. And what's the difference? Well, if the international law points to a contracting state, then the court applies the Vienna Convention. If it points to a non-contracting state, then the court applies the domestic law of that state. Is that understood? I'll show you I made a little. Is this readable? Can you read that?
Yes.
Good, thank you. So you see, you have two possibilities. Either the two parties have their place in two different contracting states, or one of the parties is not having its place in a contracting state like India or England, and in that case, the court. Well, there are two the private international law points either to a contracting state or to a non-contracting state. Is it to a contracting state, then you apply the Vienna Convention. If it's not a contracting state, you apply the domestic law of that state. So, for instance, English law or Indian law in my examples. And now here there's a point that often students don't understand and which I have to explain. And is this: why is it that if the international private law points at the law of a contracting state, why is it that then the Forum Court has to apply the Vienna Convention? Well, the reason is, and that's what students don't understand, the reason is that in that case, well, not in that case, but that the Vienna Convention is part of a state's law. You see, when I look at the law of a contracting state like China, the Vienna Convention is not a foreign law; it is Chinese law. It is Chinese law. It is incorporated in Chinese law. If the private international law points to French law, well, French law, that's not only the domestic law of France, French law, but also the Vienna Convention, because the Vienna Convention became part of French law, like it became part of Chinese law. See? And that's why I said here that, well, that's why Article 11b says that if the private international points at the law of a contracting state, then it applies the Convention of Vienna. Is that clear? That's sometimes difficult to grasp for a student, so you must look out here. It's not complicated, but you must look out to understand really what is meant by those two articles 11b and 11a. Where it becomes a bit more complicated is here. Some states made, and they had that was part of the convention, of the treaty which they signed. They have the right, and some states did it, to, at the moment of ratification, of signing of the treaty, when they sign the treaty, they can make a declaration. Article 95 gives that possibility. They can make a declaration by which they say that they are not bound by Article 11b. So, and China did that. America too, the United States of America and Singapore and Czechoslovakia, well, Czechia and Slovakia, and China made this declaration. So they are what we call in our jargon here a 95 declaring state. So they are, China, for instance, is a contracting state because they ratified the Vienna Convention, but they are also a Article 95 declaring state because they made a declaration under Article 95. And that means that even to understand what that in fact means in practice, it means that even if the private international law, the PIL, the private international law, points to a contracting state which incorporated, of course, the Vienna Convention, even if normally they should apply the Convention of Vienna, they are not bound, they will not apply the Convention of Vienna. That's also the case for China. That at least what I can read in the books. I don't know if the courts or the case law really applies Article 95. That would ask some research in the Chinese case law. That's work for a master thesis. So do you understand that? Perhaps I'll show you what's meant here. So that's an exception to Article 1(1)(b), and the exception, you find it in Article 95 of the Vienna Convention, which gives the right to any state who is ratifying the convention to make a declaration by which they say that they are not bound by Article 1(1)(b). So that makes it a bit more complicated, but not too complicated, isn't it? But no, where it becomes more complicated, there is still this to say. Some states who are declaring, who are contracting states, like Germany. Germany is a contracting state. It means they have ratified the convention. And they didn't make a declaration under Article 95. So normally there should be no difficulty. Normally they should apply Article 1(1)(b), 1(1)(a). But the case law, it's not in the text, it's not in the text of the convention. You will not find it in Article 1 of the convention. It's not there. It's case law, it's German case law. That's what the German Bundesgerichtshof decided. And they did that out of reasons of courtesy, international courtesy. And what they do is, if one party, so a businessman, a seller or a buyer, if one party resides in a 95 declaring state, which is, of course, a contracting state, of course, at the same time, well, the court will not apply Article 1(1)(b). They don't apply the Vienna Convention. They don't apply the Vienna Convention. What do they apply then? That could be your question. So what do they, if they don't apply the Vienna Convention, well, no problem. Then they apply the domestic law, which is pointed at by the PIL, by the private international law. Is that a bit clear? Shall I repeat that? So let's start again. When you are a judge, or you are a student who are making an exam, but you have to decide, well, shall I here in this case, which I have to give a solution to a case, shall I have to apply the Vienna Convention, the Convention on the International Sale of Goods of 1980? Shall I have to apply it? Well, I look at the two parties. Do they reside in two different countries? Are these two contracting states? If the answer is yes, okay, you apply. You apply the Vienna Convention. If the answer is yes, they are in different countries, but one of the parties doesn't have its place of business in one of those countries is not a contracting state, then you don't apply immediately the Vienna Convention. You must look at your private international law. And there you have a choice possible. Perhaps your private international law says it points to a country which is not a contracting state. Well, then you don't apply the Vienna Convention, you apply the domestic law of that country. Or the international private law points to a contracting state, and then there, because a contracting state incorporated the Vienna Convention, you apply then not the domestic law of that state, but the Vienna Convention. A difficulty is that some states made a 95 declaration, and you must look up. You look up in your text Article 95. You look it up, but you see it's what I'm. But you have to look at the text. Each time when I mention an article, you must look at the text. We are lawyers, so when we have to find an argument, we must cite the article. So when one of to come back to my reasoning, to one of the parties doesn't reside in a contracting state, then you must apply the private international law, which points either to a contracting state or not. But it is possible that he points to a he points to a contracting state, but that state has a special case law. They it's possible that not the case law, but that state made a declaration under Article 95, and then you will not apply 1(1)b, but you apply the domestic law of that country. Difficulty if the forum court, if the judge who has to decide the case, the forum court, if that forum court is a state which didn't make a declaration under Article 95, but which as a case law, the highest court, for instance, in Germany, declared that even if the forum court is situated in a country which is not a declaring state, but even then he will not apply Article 1(1)b out of courtesy, because he thinks, well, if one of the parties is residing in a country which doesn't recognize, which doesn't want the application of the Vienna Convention, okay, I will not force them to accept that. I recognize that, and I will not apply the Vienna Convention. So that's Article 1. Remember, 1(1)a or 1(1)b. With the complication of Article 95 and with the complication further of the possible case law like in Germany. Remember well, if you are a Chinese judge, that if Article 1 obliges you to apply the Vienna Convention, if the Vienna Convention is applicable according to Article 1, then you must apply the Vienna Convention. It's an order which is given by the Chinese state, because the Vienna Convention is a treaty which was signed and ratified by the Chinese state. So the Chinese state obliges his judges, his courts, to apply the Vienna Convention. If all the conditions of the sphere of application are fulfilled. You see? So they have you to know if you must apply it, you must look at, as we said, Article 1, 1.1a, 1.1b, and you have also to look at Article 95, and eventually you look as a forum court if the case law of your own country didn't make that special exception. That's one thing. And then there's a thing I didn't mention up till now. This is it is possible that although the Vienna Convention has not to be applied, the parties in a contract, freedom of contract, of course, the big principle of freedom of contract, parties can in their contract of sale put a clause saying, well, between us, because we find it a very good convention, the Vienna Convention will apply. We call that a contract in clause. Although you are not, the parties say, we know that normally between us, the convention is not applicable. For instance, between an Indian seller and a Chinese buyer, in principle, the Vienna Convention will not have to be applied because India is not a contracting party. But in the contract between the Indian and the Chinese, there can be a clause saying, because the two parties were agreed about that, saying, well, on our relationship, the Vienna Convention will apply. We find that a good convention, it gives a very reasonable, fair solution to all the problems which we could encounter in our relationship. Well, if we have got made that we don't have litigation, but if we have a litigation, well, okay, then the Vienna Convention will apply. We contract in the clause, that's possible. Freedom of contract is a big principle of the Vienna Conventions. Parties are free to make a contract like they want to. The reverse is true too, even in cases where normally the convention, Vienna Convention, should apply according to the sphere of application. Normally, convention would apply. Parties, if they agree, no, we don't want this convention, they can. That's contract out. Instead of contract in, they contract out. So they say, well, we don't accept the Vienna Convention to regulate our relationship. Is that clear? Now, I have to say also, just for the clarity, I speak in my, up till now, I often use the term forum court, the forum court. Forum court means the court which has to hear the case and to decide the case. If the case is brought before a Chinese intermediate court, well, the forum court is that Chinese intermediate court. If in another case the court is brought before a court in Singapore, the forum is that court in Singapore. Now, the forum court, where the plaintiff brought the case to try to obtain a solution, must have jurisdiction. He must be competent in the procedural sense of the word. He must be competent, he must have competence, he must have jurisdiction to decide the case. And that's also a difficult question in international, well, for international lawyers who are busy with international practice. It's an important issue to decide when they have a client who arrives with a problem. It's a difficult question to say, well, before what court, before which court will we bring our case? That's a place where do we have a court who probably will accept that they have jurisdiction. Well, this is a question which is important, but which we don't decide in this course. It's, like I said, that I don't speak about international private law. That's a special course, you have it. I don't speak of jurisdiction. That's also not a part of this course. I suppose then, when I give an example, that the court which has to decide the case has jurisdiction, and the court will first of all, of course, examine that question: do I have a jurisdiction? And that the answer you will find in very often in international conventions, in an international convention between states. I remember last exam there was a question where to solve the case, the first question was, does the court has jurisdiction? And one of the students answered by speaking of the Brussels Convention. Now, I probably heard that in the course of international private law, but let me specify the Brussels Convention. Yes, that's a convention that's important for European states. For instance, when you have a problem between an Italian seller and a Danish buyer, or between a Belgian seller and a German buyer, which court has jurisdiction? Well, you have to look at the Brussels Convention, because that's European law. It's a convention between the European states. But of course, in Singapore, they will not apply the Brussels Convention. In China, they will not apply the Brussels Convention because they are not European states. They will eventually find the answer in other conventions they have, or in, well, normally it's a convention where you find the solution. Is that clear? I specify more in detail that the forum court, who has to hear the case, to decide the case, must follow its own procedure. For instance, if the forum court is an intermediate court of Chengdu, well, that court in Chengdu must apply the Chinese Code of Civil Procedure of, if I'm not mistaken, 1991. It was modified, it was amended in 2007, I think. Well, anyhow, it's the Chinese procedural law, the law of the country, of the situation of the forum court. That's what you find here, if they have jurisdiction and the procedure. Of course, I don't speak of that neither. I don't speak about, that's course of procedural law. That's probably you saw that in private international law. A last point before we rest for a coffee. A last point is important, because I noticed that very often the student, and not only student, I saw also that Chinese courts often mix it up. Now, this point which I want to mention is that uniform law, like the Vienna Convention, like our Convention on the International Sale of Goods, uniform law is opposite to domestic law. If you can't apply both, it's either uniform law or domestic law. So the court cannot apply both. You can't apply at the same time uniform law and domestic law. And why did I say that sometimes I see that Chinese courts do that, but it's wrong? That's because I see that in some judgments, the court starts by saying, yes, in this case, we see that the Vienna Convention has to be applied, and they discuss the case. What do I see? Then they apply Chinese law. Well, that's not possible. If you say that the uniform law is applicable, you must apply the articles of the uniform law and not the articles of Chinese civil code, for instance. Is that clear? That's an important, and it's pretty important. If you understand that, then I think you understand what the uniform law is and requires. Now, next lesson, not now today, but because today we continue, we have a second lesson, but in the third lesson, we will see an exception to that. We will see a very important exception, and that exception is this. Although the court must apply the uniform law, in some cases, when you have a gap in the uniform law, you can't do otherwise. You must apply, and the article says, it's Article 7, you must apply domestic law. So although you say, I must apply and you apply the uniform law, but because there's a gap in the uniform law, you must apply the domestic law. And I give you an example. That's called, technically, this is called, we see that when we are in lesson 3, it's called when you have a problem which is governed by the Vienna Convention, but not settled by the Vienna Convention. Governed, but not settled. In clear language, it means when you have a gap in the Vienna Convention. I give you an example of that. The Vienna Convention says that if a buyer pays too late, for instance, the buyer receives the goods, they are delivered, he accepts them, no problem, he has to pay, but he's late, he pays only 8 months later. No, the convention, and we study that problem later on, the convention says, well, then you have to pay interest. You have to pay a sum, but eight months too late, that brings an interest of 8 months. That's fine, in principle. But what is the interest rate? Is it 4%? Is it 5%? Is it 10%? What the hell is the interest rate? The convention doesn't say it. So there is a gap. In other words, the interest rate is a matter which is governed by the Vienna Convention, but not settled by the Vienna Convention. And then to find out what is the interest rate, you will have to apply the domestic law to which the international private law points, the applicable convention, the applicable foreign domestic law. You have to apply it to find out what the interest rate is or should be. Is that clear? You have other examples of gaps. For instance, the currency of payment. If it's not defined in the contract, how do we know what is the currency of payment? Do I have in a contract between a Chinese seller and an Egyptian buyer? What is the currency? In what money must the buyer pay? In renminbi or in dollars? What was the currency of payment? Well, that too is a problem which is left to be decided by domestic law. Or the very important problem of hardship, which is not regulated in the Vienna Convention. Hardship. The contract becomes burdensome, extremely burdensome for the party who has to perform the contract. That problem of hardship is in fact not regulated. We have to look at the domestic law. Of the problem which we will meet just in a moment after the break, the problem of a delictual obligation of one of the parties. That's not regulated by the Vienna Convention, delictual obligations. Then you have to apply domestic law. Well, I propose now to have a short break so that I have a cup of coffee. And then we start with this lesson number 2, the second lesson. If you have a question, you can always mail me a question and you can ask eventually Miss Xie Hinyan, who is the student assistant. You can ask her to send me the mail if you don't find out my email address. You can ask me the question by mail. I'll be glad to answer them. Let's pause for 5 minutes. Thank you. Yes, can we start again? Monsieur, can I start again? Hello. Hello. Hello.
Yeah, yes, I'm
Hello.
back. Yeah, I'm
You're back.
back. Yeah.
Can I start again? Shall I start again?
Yes, we can proceed.
Yeah, proceed. Okay, good. Let's proceed, ladies and gentlemen, to lesson 2. But first of all, I received already a question, and it's an interesting but difficult question. It is the question if if Hong Kong, if the law of Hong Kong, well, if Hong Kong is to be considered as a contracting state, if Hong Kong can be considered as a contracting state. That's the question. Well, difficult question. Let me analyze it logically. First, before 1997, Hong Kong was an English colony. England didn't ratify or didn't sign, neither ratified the Convention on the International Sale of Goods. So Hong Kong was not considered as a contracting state. Neither did England, as England is not considered as a contracting state. Good. But what after 97? There you have a problem. You have several articles to consider. The first one is Article 93 of the Convention. look at Article 93, you will see that some states which have different territorial units, and that could be China. You have the mainland and a special autonomous region, Hong Kong, like you have an autonomous region, Macau, autonomous region. The state can make a declaration saying that although they are declaring they are a contracting state, that territorial unit is not to be considered a contracting state. They could do that. They could do that. Article 93. Some states, Canada or Australia, did that. But China didn't do that. So we don't have a special declaration here. Good. But we have another possibility where we have to look at when Hong Kong became again, well, became part of the of the People's Republic of China. It became just a part of the of the whole country, although it has its own special legal system, which is common law and not the Chinese law of the mainland, which is considered as belonging to the Continental law family. Although it has its own legislative system, Hong Kong, well, the mainland could, when Hong Kong became became part of the country again, at that moment they deposited a list in the hands of the Secretary General of the United Nations, a list with all the conventions which binds at that moment mainland China, and which in the future will bind also Hong Kong. But in that list, you don't have, no mention is made of the Vienna Convention. So what? Is Hong Kong to be considered a contracting state? Before 97, it wasn't. After 97. And so the situation is not clear cut, and the case law is divided. Some district courts in America says no, Hong Kong is not to be considered a contracting state, so the Vienna Convention is not automatically applicable. Also, the highest court in France, the Cour de Cassation, said no. Also, the federal court in Australia, no. But you have otherwise other courts, other district courts also in America saying yes, the Vienna Convention is applicable. So we don't have in the case law a clear-cut answer. And so I can't give you a definitive answer to that question. But if you would have, last year there was a question like that in the exam, you just have to explain it. You can, of course, give your personal, it's possible to give your personal view. I don't know. Perhaps you have good reasons to think that the Vienna Convention is well, that Hong Kong is to be considered a declaring state or not. It depends from eventually personal view. Say then, if you don't have a personal view, say then that at least you can't give a straight answer because the case law is divided, and you give the two arguments which I gave you. You have Article 93, and you have the absence of mentioning of the Vienna Convention in the list which China, which the People's Republic handed over to the Secretary General of the United Nations. Good. Now back to the lesson 2. We saw in the first lesson the sphere of application of the Vienna Convention. So, in principle, the two parties, seller and buyer, are residing in different states, but they are contracting states, or one of the party is a contracting state, the other one not, but the private international law of the forum says the law of a contracting state is applicable. In those cases, the Vienna Convention applies without problem. But now the question which we have to examine, it applies, yes, but not for any contract. It's only for a sale of goods. Now, that's what we are considering in this lesson. What is a sale of goods? Now, we know, of course, what a sale of goods is. Sale is the delivery of the handing over of goods, and you hand them over, and the intention is to transfer the ownership to the other party. So all contracts which don't have this characteristic, they are other nominated contracts, but they are not sale of goods. And I give you one example: a lease contract. Lease contract. Well, you can take lease in the way, in a simple way. That's a contract between a landlord and a tenant. A landlord, the owner of an apartment, who leases the apartment to a tenant. That's a lease. But you have also a financial lease, and that's something special. And that's the example I want to give. The financial lease, which can have an international dimension, is not to be considered as a sale. I'll explain you, but you have this probably in another course, in your course on the law of contracts. A financial lease is this: you have a three-party relation, three parties. You have a lessor, a lessee, and you have the manufacturer of the goods. So the idea is that the lessee wants to buy, well, to acquire goods manufactured by this person, but he has no money to pay it. And so he finds a financial institution, and the idea is that the financial institution will purchase the goods from the manufacturer, from the seller. So there will be a contract of sale here, and then the buyer, if you want, who will he will lease it to the lessee for a certain time, for instance, for 5 years. For 5 years, you see. So the lessee, in fact, could have contacted the seller, and then they made an agreement. Yes, I'll find an institution who will pay you, and that's a financial considered as financial lease. Now, this financial lease is not a contract of sale. It's a three-party, complex three-party relation. It doesn't fall under the Vienna Convention. But we find, for instance, a decision of the German highest court, the Bundesgerichtshof. It's a decision of 2014, saying that when at the end of the financial lease, so the 5 years in my example are over, then the lessee eventually can repurchase the goods at a lesser value, of course. If he used it for 5 years, after 5 years, he will, if it's a car, for instance, he leased a car, well, after 5 years, he can obtain from the lessor, who is the owner, it's the lessor who is the owner of the car, who leased it to him, he can obtain for him a repurchase, sell it back to me at a very low price, because after 5 years was the value of the car anymore. So the repurchase of the car, that's the repurchase of a car is falling under the Vienna Convention, said the German Bundesgerichtshof. That's for the sale. And then you have a second aspect in my expression, sale of goods. The goods, what are the goods? Well, the goods are, first of all, movables. They must be transferable. They can be transferred by train, by plane, by car. They are by eventually just by me, yeah, but I have to transfer them. Movable excludes, of course, a real property. A real property doesn't fall under the convention. If a Chinese sells an apartment to someone to an expat from Belgium, this is not falling under the Vienna Convention. Real property, so immovables, don't fall under the convention. But movables don't mean necessarily corporeal, so that you can touch. It's not necessarily corporeal. For instance, software can, if you sell software for computers, this falls under this can fall under the Vienna Convention. What about goods who don't exist yet, so future goods? So the goods have still to be produced, manufactured. Well, they can also fall under the Vienna Convention. So that's for the first notion, sale of goods. But Article 2 of the Convention, Article 2 excludes some sales which correspond to our definition of a sales contract. They are sales contracts, but they are excluded. And you have the list in Article 2. I can give them to you. First of all, that's important, goods which are used for personal use or household, for the household, for the family. It's not to sell, it's just I use it in my household. That's consumer sales. Consumer sales don't fall under the Vienna Convention, because you see, in a lot of domestic laws, consumer sales have a special statute to protect the consumers. So there are special rules in each domestic system, and the treaty don't want to touch that. So the convention is not applicable on consumer sales. I note here, because that's something which could be confusing, that this doesn't mean that the contract falling under the Vienna Convention must be a commercial contract. I didn't say that. You see, a lot of domestic systems, for instance, the Belgian system, the French system, make a distinction between civil law and commercial law. So you have a distinction between civil contracts and commercial contracts. That's a distinction which is important in France, for instance, in Belgium. But and it was in the Hague Convention on International Sale of 1964. I mentioned it in the first lesson. They had this distinction. Not anymore. So the Vienna Convention does not make a distinction between civil and commercial contracts. But they have they exclude consumer contracts, consumer sale. So when the goods which are bought are only used for the household of the buyer. Second excluded sale, sale by auction. Auction, it means auction is a public sale by an auctioneer who sells in a public rule, who sells it, and the highest bid will have it. You have it, for instance, in sales rooms like Sotheby's, or Christie's. You have that famous auction hall in London, but you have now also in Hong Kong. You have auction halls of Sotheby's and Christie's where they sell in public pieces of art, a painting of Picasso or antiques, and the highest bidder have it. So you have an auctioneer. Yes, I have a candidate. 10,000, 10,000, 12,000, 14,000, 20,000, 30,000, 30,000, no more, no higher bid, no. 1, 2, you have 30,000. That's the one who bought it. Auctions doesn't fall under the Vienna Convention. Third, the sales by authority of law, where the sale has to happen under the control of a court by an officer of the court. There is a special, in the procedure law, a special procedure to sell goods by authority of law. Fourth exception, stocks or shares in companies. The sale of shares in a company is not falling under the Vienna Convention. The reason behind is that those sales are often in domestic systems, or nearly always submitted to mandatory rules of the domestic law. So the convention doesn't want to intervene, and the convention is not applicable. The same for negotiable instruments. Negotiable instruments like checks, bills of exchange, promissory notes, bearer bonds. Negotiable. Negotiable means that you can easily sell them and transfer them from hand to hand. Negotiable instrument. But what you sell is in fact a writing, an order to pay. That's what you sell. That's not falling under the convention. Or money. If you sell money, I sell bitcoins or Chinese renminbi or dollars or of euros. It's not falling under the convention. This sale of goods, special goods, money, isn't fall under the Vienna Convention. Or ships, a ship or an aircraft, a plane, doesn't fall under the sale of ships or airplanes doesn't fall under the Vienna Convention. Reason is that those goods are submitted to special regulations. Such a sale must be registered. There is a special registration at a national authority, national aviation authority, for instance, for planes. So it doesn't fall under the rules of the Vienna Convention. Neither does electricity. That's a bit more difficult to understand, because in my eyes there is no reason to exclude electricity. But that's the text. The Article 2 said electricity doesn't fall, sale of electricity doesn't fall under the Vienna Convention. Then you have Article 3. There are two cases of sales which are excluded also. Besides the one excluded in Article 2, you have also two cases excluded in Article 3. And the two cases are, first, the buyer of the goods who are sold to him, the buyer, he himself supplies materials to produce the goods. He supplies and that's a word, substantial part. A substantial part, let's say 70%, 80% of the materials, of the total of the materials used to produce the goods, are supplied by the buyer himself. Well, that contract of sale, of course, is not falling under the Vienna Convention. Or second case mentioned in Article 3, there is a seller. The seller supplies goods, yes, he supplies goods. So normally you would think it's a sale. Yeah, but he sells also services. He doesn't sell them, of course, services. He delivers services. For instance, he delivers a computer system, but also he will upgrade the system at regular intervals. He will upgrade it. So he is doing something also. Not only delivering, he has to do something. Well, if the services which is rendered is and here's the word, preponderant part of the total transaction, let's say more than 50% of the total transaction, of the total value, then it doesn't fall under the Vienna Convention. Then you have Article 4. But does anyone follow up till now? So what we saw is, after having said in Article 1 that a contract is international if the two parties are residing in a contracting state, or if one of the parties is not residing in a contracting state, and the private international law points at the law of a contracting state, then it will be applied to the Vienna Convention. Vienna Convention, and that's what we saw now in the lesson, who concerns contract of sale of goods. And then the question we asked was, what is a sale of good? And what is not a sale of good? Because what is not a sale of good doesn't fall under the Vienna Convention. For instance, a lease contract, financial lease, doesn't fall under the Vienna Convention. The sale of real property, an apartment, doesn't fall under the Vienna Convention. And then you have sales which are explicitly excluded. Article 2, for instance, electricity, and Article 3, substantial part of the product, of the materials are delivered, are supplied by the buyer, or a preponderant part of the transaction consists of the services rendered by the seller. That doesn't fall under the Vienna Convention. But then you have Article 4, and that's sometimes a bit more difficult to understand. Some litigation, even if it is a contract of sale of goods, it is a contract of sale of goods, but the issue which is in litigation, the problem which the court has to solve, is excluded by Article 4. And we have 4 articles excluded by Article 4, which I will comment in a moment. Well, let me sum them up, and then you have them all. 1, validity of the contract. 2, delictual obligations. 3, products liability. 4, the property, the question of the property of the goods. Let's look at those 4 excluded issues. So I repeat, the problem is in Article 4 that although it is a contract of sale, the problem which is submitted to the court and which has to be solutioned is an issue which is excluded. The first excluded issue, validity. Validity of the whole contract, for instance, because there is a mistake. You saw that in your class on the law of contracts, isn't it? A mistake or a fraud, dolus, or duress, threatening, or violence. So fraud, duress, mistake, or for instance, if a clause in a contract, for instance, a disclaimer clause, a clause in which you say, I will not be responsible, I will not be liable for this or this reason, for that or that problem, I will not be liable, a disclaimer, well, it could be unreasonable. Well, that's not following that question. It's for the domestic law. It's not for the Vienna Convention to answer that question. Validity of a clause. Second issue, delictual obligations. First, perhaps to make you well understand what I mean by delictual, I perhaps give you some fundamental distinction in comparative law. In continental law system, like German system, French system, Italian system, Chinese system, it's considered as a continental system because the German law was very important. He belongs to that family. In continental law systems, you have the law of obligations, and the law of obligations is falling in two parts. You have the law of contractual obligations and the law of delictual obligations. Contracts and delicts, and quasi-delicts. So delicts, quasi-delicts, and contracts. But that's all bound together by obligation. Now, in the common law systems, law of the mother of the common law is of course England, the English law, but also America, Australian law, Canadian law, the law of Hong Kong, that's belonging to the common law family. Now there you don't have this notion of obligation. You have two branches, different branches of contracts. You have, of law. You have contract law and torts law, the law of torts. So to make it very clear for you, when a student in Belgium has to study law, he gets one course of obligations, contractual obligations and delictual obligations. A student in England has two courses with different professors. He has one professor for contract law and one professor for torts law. So there are two branches. I had to explain that first because you will see I need that distinction because an example which I will give is a tort of misrepresentation. When a seller misrepresents the quality of a good, it can be negligent misrepresentation or even fraudulent misrepresentation. Well, they are in common law. That doesn't belong. The remedies don't belong to the law of contracts, but to the law of torts. I'll show you that as follows. Can you see that? Wait a minute.
Yes, we can see that.
You can see it. Good. So here is the separate contracts, torts. Here not. You have obligations. That's it's important to understand that because otherwise you will not understand my example. Now, the convention doesn't speak of torts. The adjective is tortious. tortious obligation. The convention speaks of delictual obligations in Article 4. Let me see, Article 4. Article 4. Oh no. They don't mention it. They only say the convention governs only the formation of the contract and the rights and obligations of the seller. Of course, the obligations, what are they? Contractual obligations, but what if they are delictual obligations? And that's my problem. Well, delictual obligations don't fall under the convention. Now, let me explain that. Delictual obligations, first aspect is the obligations vis-à-vis third parties. If the buyer or the seller is liable, seller, if he delivers defective goods, he is liable. Someone suffered, was injured by the defective goods, but a third party never has can never sue under the Vienna Convention, because that's fundamental. The Vienna Convention is only inter partes. Inter partes. It means it's only the obligations, the rights and obligations between seller and buyer. That's the convention. That's the Vienna Convention. The relations between seller and buyer. If a third party sues one of the both, that's domestic law. That's the Vienna Convention is not concerned by that. But when I speak of delictual obligations, it's not only one against the third party or against a third party, it's also between parties, between the two parties, between seller and buyer, there can be delictual obligations. I'll give you a clear example. Culpa in contrahendo. You saw that in your course, in your class on contracts, on the law of contracts. The culpa in contrahendo. Culpa, fault in contrahendo. In the process of making of the contract. It's still not a contract, but the contract is in negotiation. And their fault is committed by the party who will become buyer or seller. So culpa in contrahendo. For instance, a very common example, also in international trade, there are negotiations going on between the parties, and one of the parties will terminate the negotiation in bad faith. In bad faith. In bad faith, it terminates the negotiations. There is not yet a contract, so you can't speak of contractual obligations between the two parties because there is no contract yet. The negotiations were broken off, but it's nearly, there's a problem of the law of contract. It's called culpa in contrahendo, the breaking off of in bad faith of the negotiations. Well, that of course is not governed by the Vienna Convention. So the Vienna Convention doesn't speak of negotiations breaking off in bad faith, or culpa in contrahendo in general. Vienna Convention doesn't speak of that. It's not falling under the contract law. Up till now, clear? But, of course, I must always try to make it a bit more difficult. But here is and there I will need now for this question, I will need my distinction between continental law and common law. But there is a there is a controversial question of if the court or the arbitrator, because when I say a court, it can always also be an arbitrator. And if the court of an arbitrator can supplement above the Vienna Convention, more than the Vienna Convention, supplement a remedy of the domestic law. Is that possible? That's controversial. I'll give you an example. Imagine that you have a sale of a machine, and the machine is not, as the convention would say, not conforming. It's defective. It's not a conforming good. So you have rules about that. We will see them, we will study them. The rules, Article 35 of the Convention, about what to do in case of defective rules. But you have also an Article 39 saying that you have a 2 years cut-off period. So it means if 2 years after delivery there is still no notice which is given of the defect, there is still no notice of the non-conformity of the goods which were delivered. After 2 years, we will see, then it's too late. You can't obtain, the remedy is lost. The remedy is lost. Okay, if this is the case, and the remedy, poor buyer, the remedy is lost. He lost it. It's too late. And then the question is, yes, but if it's an English buyer, and if the English law would be the domestic law which could be applicable, could he, although that he can't have a remedy on basis of the Vienna Convention, couldn't he sue before the English lawyer, English court, or an arbitrator, basing his claim on the English law of torts, not contract, torts, because representation could be fraudulent misrepresentation. That's a tort. Well, can he sue on basis of tort? Well, that's a problem. This is controversial. The authors don't agree about it. You can discuss. I will not discuss this here because it brings us too far. But that's a problem. That's why I just say it's controversial. Could be yes, could be no. Anyhow, what I can say is this: courts or arbitrators should be careful, restrain, don't accept too easily that besides the Vienna Convention, you can also, to supplement it, apply domestic law. Because that brings the whole idea of a uniform law in danger, isn't it? Third case, products liability. Well, I mean by that the liability of the producer of defective goods. For instance, the producer of toys for children, toys which are made by a material which is poisonous. So if kids, small children, bring them at their mouth, what often happens, and kids do that, they are poisoned. Not perhaps immediately, but it's poisonous for them. So that's a defective product. A toy which is made up of material which is poisonous, which is not good for the health, that's a defective product. That's will the seller be liable? Yes, on basis of products liability. But what about what does the convention, the Vienna Convention, say? There we have to analyze it. First problem: death or injury. Injury, that's my example. The child is injured. Or even if it's worse than that, the child dies. Think of milk which is which contains too much dioxin, and finally the child is you have this problem. You had this problem years ago in China. The contaminated milk, and the child dies. So death or injury of the consumer. If it's a third party, or if it is a party, just a contractual party, is the same. It is excluded. That's not regulated by the convention. You have no remedy on basis of the convention. You have to use the domestic law, which is applicable according to the private international law. So death or injury to third parties or inter partes is the same, excluded. But besides death and injury, you have also damage to property. And that's the answer is not the same. It's the same for third persons. If a third person is suffers damage in his property because of a defective product which was sold to a buyer, but the buyer used it and then it caused damage to a third party. The third party can't sue on basis of the Vienna Convention. That's clear. That I don't have to explain that. I explained you that the convention is only between parties, inter partes, between seller and buyer. So that's clear. But the contrary is not true for parties. It is possible that the damage suffered to property of the buyer, for instance, is caused by a defective good. So the goods which were defective cause a damage to other property of the buyer. Can he sue on basis of the Vienna Convention? And here the answer is yes. Here the answer is yes. Why? Because a seller is liable for all loss caused by his product to the other party as a consequence of the breach. That's Article 35, non-conforming goods. All the consequences of the breach, he will be liable for that. So inter partes. I'll give you two simple examples. First one, leaky fish tank. So a buyer buys a tank with fish in it, and the tank is leaky. There are leaks, so the water drips out of the tank. Of course, the tank which was bought, and the idea was it must, of course, contain the water without leak. So that's, of course, a defect of the product you bought, of the goods you bought. The tank is leaky. Yes, but leaking water could also damage the business premises. The tank was placed in a space, in a special place in the shop of the buyer, and there the water caused damage. Well, this damage, it's not damage to the tank itself, but to the other property of the buyer, is damage which must be which will be compensated. And in order to do that, the remedies you find them in the Vienna Convention. Another example, you buy fish. A lot of fishmonger buys a lot of fish, and the fish is living fish. They are still living, but they are kept until the moment that they will be sold. So they are living fish, and the fish which is delivered and bought is virus infected. That fish which is virus infected is, of course, non-conforming good. The seller will be liable for that. Yes, but not only for that. The virus-infected fish, living fish, infected all the living stock, the other fish owned by the buyer will always be infected by the virus and die. They too will die. Well, that damaged not only the fish which he bought, but also all the fish which died due to the virus as a consequence of that delivery of virus-infected fish will have to be compensated. Good. And then you have a last point, and that's the question of property. Look at Article 4. Article 4, and where is it? Here. Look yourself, look at your article. Article 4. This convention is not concerned with the effect which the contract may have on the property in the good sold. What do I mean? Or better, what does Article 4 mean? Well, the property, that's of course the ownership, but also other rights in rem. You know, you saw that in your law of in your laws, in your civil law course, you have a difference between a right which is a personal right. I lend you money and you have to pay it back. That's I have a personal right to claim it from you. You have a personal obligation towards me. That's a personal right, a right in personam. But you can have also rights in rem, to use the Latin term, rights in rem. For instance, in a pledge, you can have a right of pledge. That's a right in rem. An hypothec, well, that's for real property, for immovables. An hypothec, a mortgage, that's of course a right in rem. You know that distinction. I don't have, it's not my task to explain you that distinction. But when they speak here in Article 4 of property, they mean rights in rem. That's easy to easily understand Article 4. Think of ownership. Ownership is, of course, the right in rem par excellence. It's the right of the right in rem, ownership. Well, between parties, the question is, when does ownership pass? And we know, of course, by a contract of sale, that's the ultimate aim of the parties. When I buy a car, what do I want? Well, I want to become owner of the car. Of course, you must deliver it. It must be in good condition and so on. But I must be owner of the car. The transfer of ownership is important. Is important. But when do I become owner? That question is not answered by the Vienna Convention. Between brackets, in French law or in Belgian law, in all the law systems of the Romanistic family, the two ownership and risks, we will meet risks in another lesson, but the transfer of ownership to the buyer and the transfer of risks from the seller to the buyer in French law are together. They are transferred at the same time. At the same time, and the ownership and the risk they are transferred at the same time. In French law, not so in Chinese law, for instance. But so you see, this question of ownership transfer it could be a difficult question. Now, between parties, when does the buyer become owner? It's not answered by the Vienna Convention. And for instance, I can send you an arbitral decision of the Chinese CETAC, the CETAC decision of 2008, where goods were sold and delivered to the buyer, but then the buyer had to return the goods because he didn't pay, so he had to return the goods. And the problem was, because creditors of the seller would try to seize them, the problem was at what moment exactly did the ownership transfer back to the seller. So the seller sells the good to the buyer has to return them, he returns them, but when exactly, at what moment that can be important, at what moment does the seller becomes owner again? The CETAC says, well, that's not, I don't have to find a solution in the Vienna Convention. That's domestic law. In fact, in here it was Chinese law. You have to solve that question by Chinese law, said the CETAC. The same, very important in the law of sale, the retention of title. You know what that is, retention of title? That's when the seller sells the thing, delivers them, but in the contract it is said, as long as the price is not paid, the seller reserves his ownership, his right of ownership. He reserves it for him. In French, it is le droit de réserve de propriété. He reserves it for him. In English, the English term is retention of title. He retains the title of ownership. So he stays owner until, and the parties agree about that. There's a clause, the clause of retention of ownership. The seller remains owner until a certain event, for instance, the payment of the price. So, but this rights, this clause of retention of title, no solution. The Vienna Convention doesn't speak of that. Okay, so that's inter partes. I gave you a few examples of cases wherein that question becomes important. When is exactly the ownership transferred? But that's inter partes. You have also the problem against third parties. Let's look at that. For instance, you have the problem of a seller. Perhaps he's not the owner. He doesn't know it. Perhaps he's not the owner, and he sells a thing. Can the buyer becomes the owner, although the seller was not the owner? No, in civil law, also of Chinese civil law, you have an answer to that. The problem is, can the buyer, who is in good faith, he didn't know it was not, for instance, a stolen good. He didn't know it, and he didn't have to know it. He didn't know and didn't have to know that it was stolen. But he can become because he is in good faith, he can become the owner due to the contract of sale. Is the buyer in good faith? Can he cut off the rights of third parties in the sold goods? Well, that's a problem which is not, of course, answered by the Vienna Convention. Or a last example, if a seller has a right of restitution of the goods, so a seller of goods which are transported by ship, arrive in Shanghai, and the buyer in Shanghai, for instance, doesn't pay. So the goods must be returned eventually to the seller. The right of the seller to have the goods returned, the right of restitution, a right of restitution, we speak about that later. Well, that could be restricted by the local law protecting the rights of creditors. The creditor of the buyer, the creditor of the buyer have rights, they could seize the goods, but now the buyer who didn't pay have to return them. But perhaps you can say, oh, no, you can't return them because we have rights on those goods. We can be paid by selling them off. But this is by the local law, but in the meantime, the seller who, according to the Vienna Convention, has a right of restitution, well, his right is limited, is restricted by the local law. But this question is you see, the domestic law can have importance, but it is not regulated by the Vienna Convention. And that's, I think, the end of this lesson. That's what I had to tell you about articles 1 to 6. That was the object of the lesson of today. So we see each other next time for next lesson. Thank you very much.
Hi, Professor.
Yes.
Yeah.
Was that clear?
Yeah, pretty clear and understandable.
Thank you. Are you, last year, they already